Dear friends and my junior colleagues particularly, today I am going to share with you one session trial which was conducted by me before the court of Honorable C. Court of Honorable Additional District and Session Justice Kingawkar, sir, who were later on elevated as High Court Judge at Nagpur. The said session trial was under Section 376, read with Section 108 and 34 of IPC. As per prosecution story, the accused number 1 and 2 had committed rape on the prosecutrix. Initially, the accused number 1 committed the rape, and thereafter the accused number 2 committed the rape on prosecutrix, whereas the accused number 3, who was denoted as abettor, that is, helps in committing the said crime, and to the accused number 1 and 2, and 34, that is, act done in furtherance of common intention by more than one accused. So far as per prosecution story, the accused number 1 first committed the rape on the prosecutrix. There were some love affairs between them, and accordingly, and thereafter the accused number 2 committed the rape on her, and accused number 3 helps both the accused number 1 and 2 in committing the said offence. The charge sheet was filed, and thereafter the accused number 1 was represented by the seasoned criminal lawyer, senior lawyer particularly, solely practicing on criminal side, and whereas I represented the accused number 2 and 3 in the Eastern Session trial. My client was from Bengal. He was serving as a waiter, and at the initial stage he told me that as there was nobody to take the bail of him, he was under trial prisoner, and he told me that, sir, I have no money with me, there is no any relative of me here. I was serving as a waiter in that particular hotel, and the police had forcibly made me the accused in the Eastern case. I have done nothing as stated in the Eastern case. From his outward appearance, I found that he was an innocent person. He appears to be an honest person also, and he orally assured me that he will send his fees whenever he will be in here or after going to Bengal. I relied on his words and conducted the trial on his behalf. I took the defense of total denial after perusal of entire charge sheet, and more particularly the post-mortem report of the prosecutrix, medical report of the prosecutrix. For accused number 1, the senior lawyer, I don't want to disclose their name here, they took the defense of consent on the basis of some photos, joint photos and letters. And they came to me and asked that which defense you are taking. Sir, I am going to take the defense of total denial, as there is no medical evidence in the Eastern case of committing the offense of rape. They told me that that is better. I am taking the defense of consent, and if you take the said defense, the said offense be amounted to gang rape. So I am not going to take the same. I have gone through the medical report again. So far as accused number 1 is concerned, There were not a single iota of evidence to show that accused number one had committed rape on prosecutrix. We received the charge sheet, the evidence was started, the senior counsel for accused number one took the defense of consent theory. As I stated in my earlier parts, that the defense of total denial is the safest defense so far as criminal case is concerned. They narrated while cross-examining the prosecutrix, the counsel for accused number one referred each and every letter, then photos, joint photos. But she denied each and everything flatly before the court. She said that there was no such affair between us, love affair between us, that is between the accused number one and the prosecutrix. And thereafter, they asked one question to the prosecutrix that first the accused number one committed the rape on you, and thereafter the accused number two committed rape on you. I immediately raised the objection to this question, and the Honorable Court, Sikkim Gawkar sir, also rightly told the counsel for accused number one that you ask anything about accused number one to the prosecutor. Don't bring accused number 2 or 3 in the picture. The entire evidence was recorded of all the witnesses. The defense of consent, that is against her will and without her consent, then it can't be amounted. If this is not disproved, section 376, that is punishment for rape, is attracted. The entire evidence was recorded and argument was made at length, and the accused number one, my dear friends, because of that consent defense, was convicted for the period of 5 years. And so far as accused number 2 and 3 are concerned, they both were acquitted from the said session trial. And for your knowledge, as I relied on the oral promise of the accused number 2, he sent me the amount of fees to me after going to Bengal after a lapse of about 2 years. My entire fees was repaid by him to me. So, only for fees, don't spoil the case of any client. That humanistic approach should be kept by us while doing this legal profession. With these views, I pause myself here and wish you all, and thanks you all for sharing my views with you. Thank you. Have a nice day.